Equalization Levy. We have our partners from KPMG and BSR on the line. So it's 10 a.m. here in Washington, D.C. in the US and 7:30 p.m. there in India. We will have people joining in, and once people join in, we'll bring them up to speed. But we can start now. So for the background, my name is Abhishek Kishore, and I work with the US India Business Council here in Washington, D.C. This is the workshop for Equalization Levy and the impact on foreign companies working in India. As you already know, that the concept of equalization levy was introduced in 2016, but it was covering only online advertisement at that point in time. So the Government of India Finance Ministry this year, later last month, amended the Finance Act of 2016, and they have now included e-commerce supply or services also in the equalization levy at the rate of 2%. To deep dive into that concept, we have two experienced subject matter experts with us, Naveen Agarwal and Rohit Jain. Naveen, a lot of you already know Naveen, but Naveen is a corporate and international tax partner and the partner in charge for the US corridor practice in KPMG India. He has over 25 years of experience across sectors, advising clients in technology, telecom, M&E, e-commerce, and consumer markets on international tax matters, including inbound and outbound investment structuring, ETR optimization, funding and cash repatriation strategies, regulatory and tax compliance and litigation strategies on advocacy matters. So he's a subject matter expert with us today. The second expert with us, we have Rohit Jain, who is a partner with Direct tax practice of BSR and Company and is based in Bangalore. He has over 16 years of experience in handling tax and regulatory advisory for a cross sector of clients across technology, software, telecom, power, infrastructure, and financial services. He has advised a number of domestic and international companies on tax issues and has extensive experience on tax treaty provisions. So without further ado, I will hand it over to Naveen to start this workshop, deep dive, and take it forward from here. Naveen, floor is yours.
Thank you, Abhishek, and a very good morning, good afternoon, good evening to all of you. At the outset, many thanks for joining this webinar today. I know we are all living in rather unprecedented and challenging times. So I'm hoping that you and your families are all safe and healthy at this point. As Abhishek mentioned, my name is Naveen Agarwal. I'm a corporate and international tax partner with KPMG in India. I'm also the partner in charge for our US India corridor. On today's webinar, I'll be joined by my colleague partner, Rohit Jain. As Abhishek introduced the subject, equalization levy is not new to India. It was introduced in 2016. Albeit with a very restricted kind of a scope. The expanded equalization levy, which has been introduced by way of the amendments that happened in the Finance Act 2020 towards the last week of March. This has stirred a lot of debate. It has also invited sharp criticism, given that industry was absolutely unprepared for this kind of a levy being introduced. And are still sort of grappling with how this will play out, given that the law is in force and effective from 1st of April. Now, this equalization levy is an amendment actually to the Finance Act of 2016, even though it was brought about by way of an amendment in the Finance Act of 2020. But the concept was introduced in 2016. So all of the amendments that have been brought in have actually been brought in the Finance Act of 2016. And in today's webinar, we will deep dive into the provisions as also the impact that this may have on the business models. Clearly, the industry was not happy that the way it was introduced, it was not part of the original bill. It was part of the amendment. So understandably so, in the wake of COVID, the fact is that this did not go through any kind of discussion or deliberation in the Parliament itself. It did not involve any prior consultation with the industry, which we've seen happening in a number of areas where the government is seeking inputs from industry stakeholders. So none of that happened in this particular levy. As also, there was no explanatory memorandum that was introduced when this equalization levy expansion happened. And again, this goes back to the fact that when this equalization levy concept was introduced, the government has constituted a committee to look into what kind of transactions could be brought under the net of equalization levy. But the scope of this levy is very, very expansive, and we'll talk about that. In fact, even goes beyond the report that was submitted, when the original equalization levy was introduced. So, the other area which is of concern to industry at large and to the taxpayer is that this levy has been introduced when the entire world is fighting against this global pandemic. Companies and countries are in a complete lockdown mode, and this is going to create significant implementation challenges for non-resident, e-commerce operators from a compliance standpoint. So what we will do in this webinar, and Devjit, if you can move to the next slide, the agenda for this.
Naveen, just one second. Whoever has joined via Teams, you can see the presentation on your screens. But whoever is joining from the phone, we have circulated this deck before this call, so we will keep mentioning the slide numbers, and you can follow along. Sorry, Naveen, go ahead.
So what we intend to do, and we're trying to do this over the next 45 to 50 minutes, leaving a lot of time for questions in between and also at the end of the webinar, is really to talk about what the expansion is all about, deep dive into the provisions. We will also take you through some case studies, and those case studies will look into various kind of business models that are currently there. And this is not an exhaustive list of all the cases that would be there. I'm sure there are many other examples out there, but this will give you a feel for how broad the equalization levy is. What are some of the additional considerations that are there? And there have been some interactions which have happened with the government stakeholders who've been participating in a few webinars and giving their point of view. They've also sort of mentioned that some sort of guidance will come out before the compliance kicks in. So we anticipate industry to be making representation on a number of issues, and we'll talk through some of these areas which require clarity. And finally, we'll take up questions. This is an interactive format. It's a workshop format, so we will pause at regular intervals and take your questions. Okay, with this sort of agenda, I move now, into the next slide. Devjit, if you could turn over. Moving on to the next slide. So before we deep dive into what is equalization levy, I think it's important to reflect on the journey that this levy has had. And India, obviously, as we all know, it's now emerging or has become the third largest economy in terms of number of digital consumers, maybe the second largest in terms of digital adoption. So, garnering revenue through taxing digital transaction has become an important priority for this government. And even before, there were developments happening at a global level, historically, India has always followed a kind of an expansive interpretation to source-based taxation of digital transactions. And these are across a wide variety of transactions. This could relate to websites or computer reservation systems, whether that itself could create some sort of a taxable presence in India, or with respect to taxation of software and other kinds of models, subscription models, advertisement models, online advertisements done through web search engines. So all of these transactions have traditionally been a matter, a hotbed of dispute in India because of the way India has sort of asserted its taxation rights on a sourcing basis. And many of these matters have still not reached finality. They are stuck at different levels in the courts, and this will have an interesting interplay with how equalization levy comes about now. And I'll talk about the interplay between equalization levy and some of the traditional methods of taxation that the government has followed. If you look at what has happened internationally, there have been a number of developments that have happened. As we all know, globally, the G20 and the OECD, the Organization for Economic Cooperation and Development, embarked on what was called as a significant project. In 2015, they basically came out with the BEPS action plans, which is base erosion and profit shifting, to realign, global taxation, between different countries to address issues of potential double non-taxation. And this was done through 15 action plans. All of this led to culminated into what was called as a multilateral instrument. It kind of got codified through that process, which had many countries participate in that, and and that basically also got ratified by India. Now, when all of this was happening in those 15 action plan, one of the action plan was also to do with taxation of digital economy. Now, that was action plan 1. Now, in while some of the other action plans, got reflected in the multilateral instrument because there was some sort of a consensus reached between the various countries. On action plan 1, actually there was no consensus reached, or there was no unified approach agreed at that point of time. And and in the absence of that, various countries decided to implement their own unilateral measures. And that's basically the genesis of how India also introduced the equalization levy in 2016, because that was one of the recommendations that was coming from the action plan 1. Now, if you move forward from there on, there was basically, several other initiatives that got started. The countries kind of looked at alternative approaches, and one of the approach was really to set up kind of an inclusive framework where a number of countries could come together and debate on taxation of digital transactions to evolve a global consensus. As part of that, a task force was set up. The task force submitted an interim report. Following that interim report, again, additional efforts were undertaken. And on the back of that, if you were to look at last year, towards the end of last year, they came out with Pillar 1 and Pillar 2, which is part of the unified approach in order to arrive at a global consensus. In between, India in 2018 also introduced a concept called significant economic presence. And this was also borrowed to some extent from the BEPS action plan, which kind of created taxing rights for India to cover a number of situations, and especially creating a taxable presence in India. Now, that SEP was basically introduced in the domestic law, but India also recognized that the SEP could not be enforced because there has been no consensus reached globally and the treaties have not been modified. So, in the Indian context, the treaties, to the extent the treaties are more beneficial, they will override the domestic law. So really the SEP provisions could not be enforced. But it did create a new nexus in favor of the market jurisdiction. So now where we stand today is the fact that there is no global consensus yet. The countries are trying to reach to some sense of consensus through the Pillar 1, Pillar 2 approach. The expectation is that the consensus will evolve by the end of this calendar year, by December 2020. But we don't know how these timelines will sort of evolve in the context of the environment that we are in. And India sort of realizing that this process could take some time, and maybe the consensus may not really emerge in the time frame that they had anticipated, has gone ahead and expanded the scope of equalization levy effective from April 1, 2020. So that's really been the journey of what's happened traditionally in India, historically, what happened at a global level, and what the developments on the Indian front have been, in terms of initiatives taken from 2016. If you move to the next slide, Devji. Devji, okay. So if I look at just going into the applicability, so the original equalization levy that was introduced on 1st of June 2016, and mind you, it was introduced on 1st of June and not 1st of April, is basically, it covered online advertisement, and these were specified services, a very restricted scope of service, any provision of digital advertising space, and any other facility or service for the purpose of online advertisement. So very, very restricted. The way it applied, it was applicable on the Indian resident payer. So it was not on the non-resident, e-commerce operator. And it was a 6% levy which had to be deducted and collected. Now, obviously, there were situations as to who would bear this cost, and in many of the situations, this would become a contractual issue between the non-resident and the Indian service provider, and so that was one particular issue that kind of emerged at that point of time. Be that as it may, in 2020, the government has now expanded the scope, and there are two important definitions which have come about, and both these definitions are extremely important. So if I look at the definition on e-commerce operator, it basically is wide enough to include, it applies to a non-resident, whereas from a perspective of the original levy, it was on the resident. It applies to somebody who owns, operates, or manages a digital, electronic facility or a platform for online sale of goods or online provision of services, or a combination of both. So basically, it applies to, there's an important aspect is that it's own, operate, or manage a digital or electronic facility. And there is no definition to what is a digital facility, what is an electronic facility. There is, of course, a definition to online, and that online definition is extremely broad, and I'll talk about that and what implications that could have. Online sale of goods and online sale or online provision of services. So again, it's not a traditional e-commerce operator as one would understand, which is largely a marketplace or an aggregator of sorts. It covers anybody and everybody who runs a digital or electronic facility. And when we talk about examples, we'll take you through how this could have a very wide implications. The other aspect is e-commerce supply or services. Here again, it applies to three sets of situations: online sale of goods owned by an e-commerce operator, online provision of services provided by an e-commerce operator, and online sale of goods or provision of services, or both, facilitated by an e-commerce operator or a combination of both. So the first two are very simple. It is basically a sale of goods or a provision of services. The third situation is the one which is basically involving a typical platform, a typical situation where it's a marketplace or an aggregator who's providing services. So one would have thought that that's really what is meant to be an e-commerce supply of services, but clearly that is not the intention here. This is a 2% levy, as Abhishek mentioned in the beginning, and it's the compliances have to be done by a non-resident operator, and we'll talk about what the challenges around that could be. We move to the next slide, please. So what all is covered within scope? As we said, it's applicable to online supply of goods and online provision of services. It applies to a person resident in India, so a non-resident providing these services to or selling these goods to a person resident in India. It applies to non-residents, so transaction between one non-resident and another non-resident in two situations, and these are referred to as specified circumstances. One is for sale of advertisements which are targeted to a customer who is a resident in India, so that is reasonably clear. But it also applies to a person who accesses the advertisement from an IP address located in India. And that could lead to very interesting situations, because hypothetically, a person who comes down to India, let's say a person comes in, checks into a hotel for a day or two in India, and uses the internet protocol of the hotel and views an advertisement. Now, this is a person who is a non-resident coming into India and just browsing through, and an ad pops up, and that creates some revenue for the e-commerce operator outside India. Now, that's a transaction between two non-residents. It is not an ad which is targeted to a customer in India, but simply because it used an IP address in India, it could be subject to tax in India. And we'll talk about some sort of real life examples of what this could mean. The second situation is also very interesting, and there'll be some peculiarities and issues arising from that, and this is to do with sale of data, something which is not defined. So data itself is not defined, but if there is a sale of data which is collected from a person who is a resident in India, or a person who uses an IP address in India, and that could also be subject to tax in India. And the question that comes up is, what data are we talking about? And is it a data that is collected now, or is it a data which is collected in the past? Because a company could be tracking a lot of data which is going back several years, and then there is a whole question about the person who's a resident in India. So whatever person was a non-resident earlier and then later becomes a resident, what happens to data that is collected at a, will you segregate between the data that was when he was a non-resident and then he was a resident? And what residency are we talking about? Residency under the income tax laws, the way they define residency. I mean, these are the kind of issues that will crop up. But the whole data monetization bit, is going to be extremely critical, because data monetization also may not happen once. It could happen multiple times. So are we looking at taxing the transaction over and over again if the monetization happens at multiple points of time? And the third part is the person who buys goods or services or both using an IP address in India. So here the person is not necessarily a resident or a non-resident. They haven't defined that, but a person who buys goods or services using an IP address in India, that is covered. And then if I look at the definition of online, the definition of online is itself extremely broad, and it basically covers anything and everything which involves telecommunication or interaction with the internet. So it could also mean a situation where I'm buying a product, by sending an email to the overseas company, or for that matter, it could also involve making a call. So are we talking about even offline medium of transactions which are taking place, not everything taking place in an online board? Again, we'll take few examples to show how even if part of a transaction happens in an online mode, and majority of the transaction happens in an offline mode, because of the wide scope of this definition online and the fact it precedes sale of goods or provision of services, means that because of the definition of online, it could have a very, very broad implication, and even partial use of technology could result in a transaction being brought to tax in India. So I'll just pause here if there are any questions at this point of time before I hand it to Rohit to take you through the remaining to the next section of the slides.
If there are any questions, folks, you can unmute yourself and ask at this point. All the lines are closed, so you'll have to manually unmute yourself and ask. Let's go ahead, Naveen.
Okay. So
this is Jay. Sorry, Naveen. This is Jay. Can you hear me?
Yes, I can.
Yeah, yes. Jay Gullish. Do we have a sense if this is personal identifiable data or anonymized data or both?
See, they obviously haven't defined data, so that it's we are hoping that some clarity will emerge on what data we're talking about. But there should be a mechanism that they can track that this is a data coming from a resident in India and it is a data coming from an IP address in India. I think that tracking has to be done. Now, if it is from a resident in India or an IP address in India, then I think it should be an identifiable data. That's clearly the case, but obviously there would be other questions around, but what this data relates to. Does it relate to even a period going before the equalization levy came in? That's a secondary question, but it should be identifiable data.
Great. And I'm sure the same question doesn't have an answer, but if one company is using Indian data and then sells it to another company that's also a non-resident, it could be two third parties that might have Indian tax liability, but they may not have a presence, right? So there's a lot of complexity there, if I understand this correct.
See, we'll have to see that who is it going to be taxed in hands of. It is going to be taxed in the hands of an e-commerce operator. So the person who is monetizing this data, which is being sourced, which is let's say a social platform, which is gathering some data around Indian customers and selling it to somebody who wants to launch a product in India, and they're sort of gathering the data. Then clearly that non-resident who's selling it to another non-resident is clearly taxable. Now, if that data gets monetized over and over again, then it is possible that on the same data which is sourced from India, each time that they make a sale to another non-resident, it could be subject to tax. But let's say if there is a sale happening from one non-resident to another, and then he further sells on that data, that again, that may lead to complications because we don't know whether that other non-resident is an e-commerce operator or not. So it can create a whole lot of complications. I would hope that there'll be clarity around what data are we talking about, and whether it can be subject to tax at multiple occasions or just once. Does that help, Jay?
Thank you very much.
Okay, Rohit, you want to move on next to the next slide?
Yeah, thanks, Naveen. Devjit, if we could move to the next slide. Yeah, so as Naveen outlined, the charge here is on the e-commerce operator, and the way this law has been brought in, uh, while there is a consideration that goes out from India to the e-commerce operator which attracts this tax, there are certain exemptions also which they have given here. And the first one is a situation where the e-commerce operator triggers a PE in India, and the supplier service is connected to such PE, then in that case, the equalization levy wouldn't apply, but the charge would still remain under the historical income tax provisions. So, again, this poses some sort of practical difficulties because many a times we have seen that, e-commerce companies getting into a litigation mode as to whether or not a PE is triggered. So in a situation where a company itself pays an equalization levy, but later on, the government's position here turns out that no, indeed you had triggered a PE. So how would the interplay between the two taxes play out is something that one needs to watch out for. So the other exemption from this 2% levy is a situation where the e-commerce operator is still liable to the 6% equalization levy, which was existing since 2016. So, at the moment there are two different regimes of equalizations levy that will run parallelly. The one which has an online advertisement and where the payout is from a resident of India to a non-resident e-commerce operator, it would continue to attract a 6% equalization levy, whereas any other charge of online service or advertisement, including an NR to NR transaction, would attract a 2% equalization levy. So that parallel regime needs to be tracked and monitored for specific cases. Of course, the government has also given a minimal threshold of INR 20 million, which is roughly $2,500 US. So basically, if an e-commerce operator is receiving consideration for Indian sales and supplies, which is lesser than this amount, then you wouldn't fall under the new equalization regime. One needs to see in that case what happens under the income tax regime, because the taxability under the existing tax provisions would still needs to be checked in that scenario.
That's $250,000, right?
That's
right?
okay. Yes, $250,000 roughly per annum.
Okay.
Devjit, if you could move to the next slide. Yeah, so the way this levy would work is the charge would be on the e-commerce operator, and there would be a payment that would need to be made by such operator. So there would be no withholding tax that would be done in respect of this levy by the consumer at large. This is different from the existing 6% levy that we see, where the person making the payment has to withhold the 6%, make a payment to the government of India. So this is a direct payment as well as filing obligation on the e-commerce operator that would ensue. In terms of the payment modalities, what they have provided is the payments have to be made in 4 quarters. So, and for the first 3 quarters, the payments have to be done within 7 days. So for the quarter ending 30th June, one needs to make the payment by 7th July. For quarter ending 30th September by 7th October, and for the quarter ending 31st December by 7th of January. There is a practical issue, that is coming out for the 4th quarter, because the deadline given for making the payment is 31st March itself. So, there is a practical difficulty here as to how would one pay the taxes as on the date when you're closing your books, and you need some buffer time or lead time to come out with the quantum of payment that you need to make. Of course, the detailed procedure for making such payment, and the tax forms to be used are yet to be notified. So we are hoping that something on this would be clarified, before the first obligation that kicks in as on 7th of July. The rest of the provisions that are there for the existing equalization levy remain, and as it is, and would also apply to this new levy of 2%, wherein if there is a delay in making the payment, then there would be of 1% per month, plus the other penal and revenue audit proceedings would continue to apply the way they are for the. Tejit, if you could move on to the next slide, please. So there is one question that comes up is, what kind of tax registration would the e-commerce operator need here, because there has to be a payment mechanism, some sort of tax ID would be required. Most likely they would require an Indian income tax registration number, but the final guidelines and the detailed procedure in this regard is yet to be released by the government. Now, one fundamental question arises is, what is the interplay between this new levy and the Income Tax Act? Because there are multiple transactions, let's say a software sale or any other online, tool that one uses, which typically the government of India has been seeking to tax them as royalty or fees for technical services. Now, what does this new levy do to those kind of taxation issues? Now, first of all, the way this levy is structured, it is not a part of the income tax law. It is outside the income tax law. So the first point is, of course, this is not an income tax levy, and hence whether can one have a recourse to a tax treaty is questionable. And at the same time, what the government has also proposed is to bring in an exemption under the income tax law from any amount that is suffering this 2% levy. That's an exemption which is currently available for the 6% category of equalization levy as well. But what has happened here is the exemption that has been brought about now for this new levy, there is a gap of 1 year, and this exemption is available only from FY 21-22. So you have a case where FY 2021, where this new levy has come for the 2% charge, there is no specific income tax exemption that has been given. We believe that at this point in time, this is an error in the way the provisions have been drafted, and hopefully this should be clarified by the government, because you wouldn't have a situation where you have a dual charge on the same transaction in the form of an income tax withholding, as well as somebody being asked to pay an equalization levy as well. So this is one space to watch out for, and this requires an urgent intervention from the government in terms of some clarification or correction. Of course, if there is a permanent establishment that is triggered for the non-resident in India, then the new levy wouldn't apply, and in that case the normal tax treaty provisions and the domestic law provisions of Section 9 would continue to apply, and all the issues relating to attribution of profits and withholding tax would still remain there for such a situation. Tejit, if you could just move to slide 11. So before we move on to the examples and the practical scenarios on how this new levy is going to impact business and compliance, is there is one important amendment that the government has also brought in. So if you recall, in 2018 there was an amendment which brought in the concept of significant economic presence under the Indian domestic law. Of course, because there was no consensus at the OECD level, the applicability of those provisions have been deferred till FY 21-22, which is the Indian tax year 22-23. In the meanwhile, what the government has also done is the new categories of transactions that are there under the equalization levy, more so in the context of sale of advertisement and data, have also been brought about in the SEP provisions. While these provisions are not active at the moment and are scheduled to become active only from financial year 21-22, but the issues on sale of advertisement data relating to Indian residents uh, would equally apply in a situation where the recipient of the consideration is not an e-commerce operator. In those scenarios, one would have to see how the SEP provisions would play out and trigger in. So the question that was raised earlier on the secondary sale of data, now that is a scenario that could perhaps get triggered or get activated under the SEP provisions if and when they apply. So with this, I'll just give it back to Naveen, to take the group through some of the practical scenarios.
Thanks, Rohit. Devjit, if you can move to the slide on case studies, which is slide number 13. Okay, so we're going to take a few case studies around different business models. Like I said, this is not an exhaustive list, but it will give you a flavor of what the issues could be under different models. So this is an example of an online marketplace. An online marketplace which is selling goods or selling services, providing services to an Indian resident. So NFCO, which is operating the marketplace for sale of goods or provision of services, and it's selling these goods or services to an Indian resident or a person who's using an IP address to place this order. Now, simple example, the fact is that the goods could be delivered either outside India or the goods could be delivered in India. I think this is not of consequence here. The fact is the transaction is between the marketplace and the resident in India. So long as the two tests are met, it's an online marketplace outside India, a non-resident operator, and a resident in India who's buying and paying for these goods or services, it will be subject to equalization levy. Now, the interesting part that comes in is twofold. Firstly, that when you sell these goods or provide these services, equalization levy is not the only thing that companies need to think about. The transaction could also be subject to other taxes, indirect taxes. So for instance, if you sell goods into India, there could be a custom duty on those goods, right? Because especially if the goods are being delivered through a physical format. If you're providing services in India, then it could be subject to, if you're an e-commerce operator and you're doing a B2C transaction. So one other aspect is that e-commerce, this equalization levy applies to both B2B and B2C transaction. So in case of services, it could be a B2B transaction or it could be a B2C transaction. If it's a B2B transaction, it is possible that the Indian resident may actually need to pay GST on a reverse charge basis because he is buying goods and the non-resident does not have a presence in India, then it could be subject to an 18% reverse charge. But if it is a B2C transaction, then it is possible that there are specific regulations under indirect tax, which are called as Online Information and Database Access Retrieval Services, OIDA regulations, which came about very recently and cast an obligation on the e-commerce operator outside India to register in India and pay GST. So this creates some interesting issues that under what situation will some of these indirect taxes apply? And if you are subject to already some of these taxes, will that get loaded on to this consideration that you're paying? And that will also now be subject to 2% equalization levy. So if I was providing, say, a service online and I had to pay that GST on a B2C transaction under the OIDA regulation, so let's say the tax turns out to be, and in that situation under OIDA regulations, probably, it will not be, let's say hypothetically taking an 18% tax, if that was applicable now under the OIDA regulations, it may not be an 18% tax, but let's say if it was. So in that situation, would that consideration, the entire consideration, be subject to a 2% equalization levy? So that's an interesting question that comes up. The second is with respect to an e-commerce operator or a marketplace. Now, what is the consideration that we're talking about? Now, the marketplace retains its own commission. Their model is such that they're getting the buyers and sellers together. They're not really normally in their, selling their own inventory. So they're acting as an intermediary. Now, would this equalization levy apply to the entire gross amount that is collected by the marketplace, or will it be subject to tax only on the margin that is retained? I think that's an important issue because many of these marketplaces are running on very thin margins and therefore this 2% levy on the gross amount can be quite a significant cash flow impact for these companies. And of course, if you are selling goods or services to a person resident outside India, then that clearly could be an unintended consequence whereby such transactions could be subject to tax in India. And I mentioned, like, if there is a situation where part of the transaction is happening through an offline mode, then clearly in those kind of situations also, this could be subject to equalization levy. So this needs the question of online supply versus supply of online goods or services becomes extremely critical, because if it was supply of online goods or services, it would normally mean digital goods or services. But the moment it is using the word online supply of goods or services, it carries a much wider meaning. So that's the first example. Any question on this example? Any observations? Any comments?
Laura, can you hear me?
Yes.
Go ahead.
Yeah. I just have a question about this example. What if the online marketplace is outside India, but at the bottom, the box, I mean, this online marketplace is providing service to Indian sellers who are helping them to provide the marketplace and the intermediary for them to sell goods to the residents overseas. Is that still under the scope of the levy, the equalization levy?
See, the point is that for listing those goods, there is also a consideration being paid by the Indian seller to the marketplace.
Yes.
So that is an issue which needs clarity, because while the transaction is per se happening between a NR to NR, the marketplace and the buyer of the goods is outside India, right? And to that extent, it is not a typical non-resident to non-resident transaction which involves advertising or collection of data, which are the situations covered. But because for the purpose of listing of those goods on the marketplace, there is a payment being made. It seems like that could potentially get covered, but hopefully they'll come up with some clarity to say that those transactions are exempt, because it's a case of an export of goods, and ideally export of goods should not be subject to equalization levy.
Okay, thank you.
It's a matter on which representation needs to be made and is being made so that the government can clarify. Any other question?
Yeah, one question. I mean, so how do you distinguish if the online marketplace is outside India? Is the consideration only PE, or is the consideration, because it's an online marketplace, is the consideration your domain registration also?
No. So if it is let's say if it is if you're buying goods through a marketplace, and those marketplaces could be registered in India or could be registered outside India. But if you're going to say a .co website, which is not .co.in, and you're purchasing a goods or services which you're subscribing sort of something online directly, then that would be a payment that you're making through your regular credit card, which in which the price of those goods or the value of the services is being charged by the marketplace, and then they are in turn paying to the seller of goods. So on the consideration that is flowing out from India through the credit card, in that sense, that will be subject to now equalization levy on that B2C transaction. It could also be a situation where it's a B2B transaction. So if it is and we'll talk about that in the context of, say, a software download or a software sale, where those could be subject to tax. So it could be anything which is ordered off a marketplace, either by way of goods or services. Whatever is the value of those goods and services, that is what will be subject to 2%, unless the e-commerce operator has a fixed place presence in India, creates a permanent establishment in India. Because in that situation, the permanent establishment becomes a taxable presence, and that company would be subject to tax on 40% on a net income basis. So those transactions are excluded. But this basically taxes transactions which were not otherwise subject to tax, because either you had a treaty exemption, or for that matter, you were taking a view that the sale of good or sale of service is not subject to tax in India.
Okay, well, thank you. So I'll have a follow-up question a little later in the presentation, and just to think about how much tax, what is the tax bracket on which the domestic organizations are coming in, and how would that compare to the foreign companies now coming under this equalization levy? What would be the total tax which each of these companies would be paying? So maybe that is something which we'll come to later in the meeting.
There's a threshold which is provided, and the threshold is very low, as Rohit mentioned. At least for the non-resident e-commerce operator, it's 20 million rupees, and the 20 million applies to the gross receipts or the gross turnover, which again can be a very low threshold in an e-commerce marketplace scenario, because the value of goods sold will be much more substantial than that. So that threshold itself, once it's crossed, you'll be subject to this 2% levy. Okay, so we'll talk about the consideration part and other issues later as we go along. So move to the next slide, which is slide number 14, Devji. Okay, so this is a kind of a variation of that model. It's just that in this case, it's the FCO owns its own website, and so it's not a marketplace. It's basically selling goods or providing services online directly to the customer in India, the resident in India, or it's providing this through an IP address, through an Indian IP address that the customer is placing an order on the website. Now the question is that obviously the question is around the definitional aspects, because it refers to e-commerce operator, and e-commerce operator would typically not include somebody which is running a website. And I take an example of a Macy's out here, that a Macy's is kind of selling normally goods through its stores, but at the same time there's a Macy.com, which is also where people can log in and place an order, and that shipment will come to India. And if that was going to happen, then would all of those transactions now be subject to tax in India because of the order being placed directly on Macy.com? So those kind of transactions which are directly through an online platform which is being done, that will be covered. But the challenge around that is on the second bullet, which is around online requisition or a purchase order followed by an offline delivery of goods or services. So in a B2B transaction, we always see that there would be a situation where the requisition is placed through an ERP tool that one may use, like an SAP or some other tool. A purchase order is placed, but that does not mean that the contract is getting done through that. A lot of the aspects of the contract are done outside, offline, whether it is negotiation, whether it is a conclusion of the contract. Number of activities related to the sales process are taking place offline. So just because you did some part of the activities, which is placing a requisition or maybe browsing the pricing of the products or any kind of catalog that you viewed, it's all involved in the whole sales cycle. Does that create a footprint, and does that create taxability for the FCO in India? The second part could be if it's a contract which involves a sale of goods plus a warranty or an after-sales support service, AMC kind of contract. And the consideration of the AMC is embedded in the value of the goods sold. Then in that situation, it's possible that the service delivery is happening separately at an India to India level. But because the value is embedded into the price that you're paying for the goods or for the services, the question will be that on what portion would equalization levy apply? And would you then isolate the post-sale activities and say that because that is delivered in the country, on a resident-to-resident basis, that should not be subject to tax, because that is in any case it's not really being subject to tax because the consideration is already paid once, so maybe you're not invoicing it separately. But it's not strictly a service which is rendered by the e-commerce operator to the client, to the customer in India. So those kind of situations also are areas where there need to be some clarity, whether there would be some bit of apportionment done there, and would those parts be outside of the equalization levy? If I move to the next slide, please. If there are any questions on this, on the second example, I can pause here for a minute before I move on. Okay, maybe if you can move to the next slide, slide 15. Now, this is a case, a simplest case of basically using a platform for online streaming of music and video content, and it could also be gaming, etc. customer using an IP address making payment for accessing such content. Now, applicability, again, this could be a situation where a person is visiting India for a limited period of time and accessing this. It could very well happen that I get onto my website or get onto my IP address in India while I'm on visit to India. Similar to what would happen if you're, say, it could also include a situation where, while we've not covered it here, but a person comes into India and books a hotel for a stay outside India. Now, this could also a scenario where the person is a non-resident, the hotel is outside India, but the booking happens in India. Similarly, here the person is coming into India, accessing some music, or accessing sort of a Netflix or downloading some music or watching a movie and sort of paying. Basically, the transaction is between two non-residents. So that also seems to get covered by virtue of this levy. It could also be a situation where I'm downloading an app which is free of cost. And there are a number of these apps which are free of cost to begin with, but then later point of time, you may add additional features and those additional features may be paid. And in the gaming scenario, you could very well have those situations where additional features of the games are subject to, you have to pay for them. And that would then, therefore, the question would be, whether you will be paying equalization levy on those paid features. As also what could happen is that while you're playing the game, if there are a number of people playing that game, there could be an advertisement which is flashing on the game and as a banner while the game is being played. And that is not necessarily targeted to the Indian customer. It could be targeted to sort of the regional footprint, or it could be targeted to a global footprint. Then because the person who's playing the game is viewing that advertisement, would that transaction now be subject to equalization levy? So very, very interesting models and scenarios could build up as you look at, depending on what kind of service or what kind of scenario in terms of who's the buyer of the service and, is it a resident or a non-resident? And again, what are the different models that are in operation? So moving on to the next slide, maybe Rohit, you want to step in here to cover slide 16?
Yeah. Devjit, if you could move on to slide 16.
Devjit, are you able to move it to the next slide?
Guys, I think we've lost her for a second. Why don't you continue talking and we'll catch up on the slides, all right?
Okay.
I actually have one question, if I could ask while we're waiting. Has there been any consideration for, determining a transaction made in India aside from using an IP address, like having the customer self-declare, Indian residency and they're kind of using an Indian address, or is the IP address kind of the final decision here?
No, so that's a very interesting question because I think it's a threshold that should be broadened. I think IP address can be a very sort of can lead to sort of wide implications, and therefore, if you would see in the GST law when they try to tax B2C transactions under the OIDA regulations, online information and database access retrieval services, they brought in some 5 or 6 conditions, whether the person has a actual physical billing address in India, whether there is a bank account in India. Although there were several conditions, and you had to fulfill at least 2 out of the 6 conditions to make sure that the transaction was brought into tax. So I think one will have to, again, this is a representation being made that just using an IP address would be a very, very low threshold to bring the transaction to tax, and they should add additional conditionalities to establish nexus. Does that help answer your question?
Yes, thank you.
Okay, Rohit, you want to continue?
Yeah, I think we're on slide 16. So this is a case of an online advertisement. So look at a situation where there is a foreign company which pushes an ad through a social media company, and this ad is, amongst others, also targets Indian residents or people sitting in India and using Indian IP address. Now, based on this ad, If the Indian person does a booking online on F company's portal, of course, the sale by F company would attract the basic equalization levy of 2%. But what it also does is that this whole transaction also triggers an equalization levy in the hands of the social media company, which is actually selling advertisement space to a foreign company here. Now, the first question that arises is how would one split the consideration that the social media company receives from the foreign company for putting out an advertisement which has a larger footprint and has a span even outside India. So that's one issue that will have to be resolved. Plus, what is happening is, look at the social media company now. There are two parallel regimes running for them. There is a 2% equalization levy which they need to pay for any sale of advertisement to the foreign company. Plus, at the same time, if they are providing advertisement services to an Indian resident customer, then the Indian resident customer would be probably deducting a 6% equalization levy on the payments that it is going to make to the social media company. So that parallel regime would be running, and of course there would be some sort of tracking that the social media company would have to do in such a situation. Moving on to the next example, which is similar to this one, Devjit, if you could just move on to slide 17. Now, this is a situation where, pretty much similar subject, where an Indian resident browses a search engine and does some sort of search on a particular product. While the person does not buy anything immediately, this browse history is gathered by the search engine company, which is a foreign company here in this example, and then this data is sold by the search engine company to a non-resident supplier, who, using this particular data, pushes an ad based on which the non-resident, the Indian person, does a booking on the portal of the F company. Of course, the sale by the F company here would again trigger a 2% equalization levy if there is an online sale of product happening. But there is also a trigger for the search engine company, which is selling data relating to an Indian resident or relating to a person who has used an Indian IP address to a foreign company. Now, what this data could be is, as Naveen pointed out at the beginning of the session, it's not been defined yet. So whether it will be your browse history or whether it's your personal data that is sitting on a social media or your behavior on any particular portal. So we really don't know what kind of data would be covered within this definition. And perhaps in the absence of any clarification, any form of data relating to an individual which gets monetized would trigger an incidence of equalization levy in India. Also, there is some amount of retrospectivity in this whole situation, because there may be historical data that may be lying with a particular foreign company which is selling that historical data to a third party outside India. Again, that triggers an equalization levy. But as rightly questioned earlier, whether multiple sales of the same data, would that trigger an equalization levy here again? So these kind of questions are still open and perhaps may need clarity from the government. So I'll just take a pause here before I move on to the next model. Any questions? Okay, Devjit, if you could move to slide number 18. Now, slide 18 is a situation where there is a sale of software. So in this case study, there is an Indian resident who logs on to the portal of a foreign company, which is the copyright owner of a software, and downloads the software or uses software as a service. Of course, once you download the software or are given some limited user rights, the user in India would be signing an end user license agreement. Now, a question arises as to whether such kind of a transaction would attract an equalization levy of 2%, or would the the position of Indian withholding tax of 10% on such software supplies continue to apply. Now, of course, there is an interplay here, but the first primary question is whether such kind of a download of software qualifies as a goods or a service, because these are the only two categories which have been prescribed for levy of the new equalization levy. Now, assuming that such a kind of a transaction falls within either of the buckets, either it qualifies as a goods or a services. Now today what is happening is any person in a kind of a B2B transaction purchasing a software is required to withhold taxes. Now, whether the government would give up those arguments of not seeking a withholding tax of 10% on such download or use of software and just continue with the position of a 2% equalization levy. Again, the feedback from the government is not pretty clear at the moment. We hope that by the time the first payout of 7th July is triggered, by the time there is some clarity which is there from the government side as to which side of the line does this kind of a transaction fall. Obviously one wouldn't want to land up in a situation where you end up to both the levies, because the person making the payment from India, to be on the safer side, might want to continue doing a withholding tax because there are onerous implications for the Indian payer of not complying with withholding tax. And at the same time, if later on the government clarifies that there is no withholding tax required, but indeed there is a 2% equalization levy, then in that case, what do you do with the taxes that have been deducted? So the sooner the positions on these standard transactions are clarified by the government, the better it would be. Of course, another dimension that crops up is many a times there is a bundled sale of software, with, let's say, a post-sale service or technical support or a call center support throughout the life cycle of the software license. Now, what happens to those kind of transactions where the support is not provided online, and would that require a splitting up of the consideration so as to say, okay, a portion of the consideration would attract an equalization levy and the portion of it might perhaps have to be tested for an Indian income tax. So those are the issues that will crop up in a scenario of sale of software.
So Rohit, let me just add one point here. So one is that from the interactions that we've been having and we've been hearing the government on this, I don't think so the intention is to tax both sides of the transaction. So it's not going to be a 2% plus a 10%. But it also means that the government has also gone on record to say that this is not an intention to reduce the 10% to 2%. So if a transaction was subject to a withholding tax of 10%, and that has been their view all along, then just because an equalization levy has come about now, it doesn't mean that you don't need to withhold tax and now only pay the 2% levy. So this is something we'll have to see how it gets clarified. And then also, as you mentioned, that many of these issues are currently under dispute because the taxpayer does not agree with the position that the payment for the software should be subject to withholding tax. And those disputes are now, many of those disputes have traveled to the Supreme Court. And we don't know when that there will be a finality on this matter. And the finality of the matter could go either way. Either the matter would be settled in favor of the taxpayer or it could be settled against the taxpayer. And depending on what that outcome is, what would be the revenue's position here is unclear, because prima facie revenue wants to collect the 10%. But what happens if they lose the battle and the government holds that 10% withholding should not apply? Will they come back and claw back and take the 2%? It can't be so that they can have the benefit both ways. But this is something which is going to be a very interesting issue and impacts the software industry at large, including companies who are in the cloud business and software as a service or traditional software. All of this is now currently under a hotbed of dispute, and how the government issues clarification on this will be interesting to watch out for. Any questions here? Otherwise, Rohit, you can move on.
Yeah. Yeah, so I think we'll move on to the next one, which is a similar transaction, but there is an intermediary distributor, which is generally a distribution model that is followed by many software sellers. So you have a foreign company, FCO Inc., which owns the copyright of the software and runs a portal. But what it does is for let's say for Asia region or APAC region, the foreign company appoints a distributor, let's say in Singapore, which is FCO PTE, and then the customers in India, interact with FCO PTE for placing the order, but while the final download of the software happens from a portal which is owned or managed by FCO Inc., while the flow of consideration is from the Indian customer to the distributor, and the distributor pays a back-end consideration to FCO Inc. The download is through the portal of FCO Inc. Now this raises a very pertinent question as to who may qualify as the e-commerce operator here, because the flow of money from India is happening to the distributor entity outside India, but the portal is owned and or managed by another country in another jurisdiction. So now this kind of a transaction may risk double taxation unless the government clarifies upfront that a transaction will not be taxed twice, because technically FCO PT may possibly not get qualified as an e-commerce operator, because that's not the entity which is running the portal, in which case you're out of the equalization levy and you straight fall under the income tax regime, which is currently under dispute on this matter. And at the same time, what happens in the hands of FCO Inc., because there is a supply of service that is or a goods it's happening online, and there is some consideration that is being received by FCO Inc. at the back end. So does that once again trigger a tax incidence in India in the form of an equalization levy? Is something to watch out for. As Naveen said, sale of software and similar transactions currently are a hotbed of litigation, and I think the government may also want to keep all options open till the Supreme Court decision is out. But from a business perspective, the sooner the clarity is, it will help in terms of planning out transactions. So I'll just take a pause here. Any questions on this software distribution model? Otherwise, we'll move on to the next case study. David, if you could move on to slide 20. Yeah. So this is a case where, and this typically happens in the case of many multinationals, where there is a central procurement of goods or services that is done, and the cost is distributed across many subsidiaries. So in this particular example that we have built up, there is an online transaction between two foreign companies outside India, FCO 1 and FCO 2, where FCO 2 is the e-commerce service provider. There is some subscription that FCO 1 takes and passes on the passwords and the relevant keys to the Indian resident company here. And the Indian resident company uses those keys and passwords to download or have access to the services that FCO 2 is providing. In this case, there is also a cross charge that comes from FCO 1 to the Indian resident company. Now, the flow of consideration will be that FCO 2 receives some consideration from FCO 1, and a portion of that cost is cross-charged to India by FCO 1. Now, whether this kind of a transaction would trigger an equalization levy, and if yes, in whose hand? Because the payment here is being released by the India company to FCO 1. Very likely that FCO 2 would trigger an equalization levy here, because there is indeed a supply of service or goods that's happening through their online portal, and it's being accessed by somebody sitting in India. But again, the timing of that taxability could be a question, because there may be a time lag between the flow of consideration from the India company to the foreign parent company, and then from the foreign parent company to the actual service provider. Now this is a very, very basic model, but look at a situation where there is a markup or an admin overhead that the FCO parent company, that is FCO 1, also loads on to the amount that it is charging to ICO. Is there a need to relook at the transaction in that scenario? Because then it means that there is something top up that FCO 1 is charging for. Does that trigger an income tax incidence over and above the equalization levy incidence in the hands of FCO 2? Could that create a scenario where there is indeed a double taxation. So this is another area to watch out for, because you again wouldn't want to land up in a situation where the same transaction attracts double levy. With this, I'll just hand it over back to Naveen for the next case study.
Okay, so I think we are now on the last case study, and I know we're a little bit over an hour, and we'll try and wrap it up, the last two slides, and then we'll open it up for questions. So this is the case study of a hotel aggregator, and we are aware of companies which are using this, using the hotel aggregator model, or e-commerce operators in the online sort of hotel booking space kind of situation. And then there could be two variants to this model. And so it could be a scenario where the booking is done, where the consideration is flowing directly to the aggregator first. So the payment is, it's a situation where the aggregator collects the gross amount and then pays, retains the margin and then pays the net amount to the hotel, which is the e-commerce participant. Or it could be a situation where you book your hotel on the e-commerce platform and then sort of pay directly to the hotel. Then the hotel in turn pays to the aggregator. So in both situations, there is a commission which is being retained by the aggregator. But in one situation, the aggregator is getting the gross amount, and in another situation, the tariff is being collected by the hotel, and then the commission is flowing to the aggregator. So this comes back to the basic issue that we talked about, that what is the equalization levy applicable on? Is it on the gross amount or is it on the net amount? Now, logically, again here, if the hotel happens to be in India, then clearly the Indian hotel in any case is paying tax on this amount. And it should not be a situation where the aggregator is also paying tax at 2% and the hotel is already paying income tax. So again, this is similar to the marketplace model that we spoke about. It would be there in similar kind of models wherever there is aggregation happening, and the gross versus net issue still needs to be clarified. But there could be various other scenarios around it, because there would be a situation where you're purchasing an inventory from the hotel, but it doesn't mean that when you purchase the inventory, the use of the hotel is happening at that point. The income is not accruing at that point when you're buying the inventory. So what will be the point of taxation? There could be scenarios where there is a cancellation of the hotel. You book the hotel and then you cancel it later, and there could be situations where you book now and pay later. So there are various scenarios that will be there in this kind of a model. And given that the equalization levy has to be paid on a quarter-on-quarter basis, this creates some challenges for the e-commerce operator on what should be the the value on which they should be subject to equalization levy, especially if these situations spill over between two fiscal years, because you need to account for it for that fiscal year alone. Also, it does create certain compliances around multiplicity of taxes. We spoke about how the transaction could be subject to tax withholding. There are new tax withholding provisions which have come in the Finance Act itself, although they have been deferred till 1st of October, but it casts a compliance obligation on the hotel aggregator to do a withholding when they make when on the payment that is made to the hotel, and that payment may not be made by them, but it can be made even by the customer directly to the hotel. But the compliance obligation on withholding tax also happens on the aggregator, so or the e-commerce operator. So that's an additional compliance that they already have. On top of that, they have equalization levy now that they have to worry about. And then under the GST law, they may have other implications depending on whether the hotel is a registered hotel or unregistered hotel. There could be some other related implications. So you can see here that there's TDS, which is withholding tax, there is equalization levy, there is tax collected at source, and then there is goods and service tax. So a lot to be worried about if you're looking at a hotel aggregator kind of model. Okay, now moving on to the next slide, which is slide 22 and the final slide. So what are the final things, if I would say? One is that the first payment comes in on 7th of July. So in some sense, you have time between now and June 30th to look at what the impact of this could be on your business, what could be the transactions that could be subject to equalization levy, and wait out for whatever guidance is provided by the government in this period. If there are matters on which you need clarity or need to make representation, now is the time to do so. So this becomes critical. The second is, of course, we talked about the interplay with income tax, the fact that there is needs for clarity on the exemption date, which appears to be an error, a drafting error, but has not been rectified when the bill got passed. So that needs to be corrected, as also the risk of double taxation that we spoke about in the context of software kind of transactions, where it could be subject to double taxation. There is an interesting issue in case of composite contracts, where it involves a supply of goods and provision of services and downloading of software. How do you allocate and apportion the consideration which is relatable to the part which is subject to equalization levy? And we will have a number of those situations which are composite kind of contracts. The other issue is on permanent establishment, that you don't determine the permanent establishment today, because that determination could happen 2 years down the road, or 3 years down the road, or 5 years down the road, depending on when your matter gets picked up under audit. And if that is established at that point of time, then what happens to the equalization levy that you pay today? Is there a mechanism to adjust it against that permanent establishment tax which is determined at that stage, or we get a refund of that? It's unclear. What happens to foreign tax credit? It's an important issue. It was also there under the 2016 law and continues to be there because it is not in the nature of income tax. Will you get a credit for this in the home jurisdiction? It will have to be evaluated on a country by country basis, looking at the provisions of the domestic law there, as also the provisions of the tax treaty. Is there a mechanism to obtain certainty around equalization levy applicability? At this point, the government has not provided any mechanism. There was a discussion that should an avenue like a ruling from the authority for advanced ruling, can that be explored? The government is open to it, and we will see if there is some sort of a clarity brought about around that when they issue the guidance. There is no registration prescribed because all the administrative procedures around compliances, forms, registrations have not been discussed in the law, but it is possible that you may need to obtain a permanent account number to comply with this requirement. Companies have been wary of obtaining a permanent account number in India because that opens the puts the transaction and the company under. I mean, the transaction would in any case be under the radar, but the foreign company would now come under the radar. And if those transactions were happening even earlier, then the question is that if you obtain a PAN and I do this compliance, could the tax authorities come after me for the earlier years and try and determine if I have a permanent establishment in the earlier years or not? So it does create concerns if it has to be a PAN-based filing or registration. So these are some of the issues. There are many other issues which are out there, but I'm conscious of time. I do want to sort of leave the last 8 to 10 minutes for additional questions that may be there.
Thank you very much, Naveen. Thank you, Rohit. The lines are open right now. If anybody wants to ask any question, please unmute yourself and go ahead. Well, while people figure out internally and prepare to ask any questions, just for housekeeping purposes, as everybody knows, we have already made a suggestion to the government of India about delaying this to the next financial year. But if there's anything after this workshop today, if you think after you go back to your internal teams, to your internal tax teams, and try and figure out if something is applicable to you and something you want to dispute or provide any suggestions and recommendations to the government of India, we will be more than happy to collate all those suggestions and recommendations and go ahead as USIBC to and submit the recommendations to the government of India. So if there's anything any of you wants to put forward, we'll be more than happy to take it and go forward. Now the lines are open. If anybody wants to ask any questions, please unmute yourself and go ahead.
Abhishek, there's a question in the chat, I believe.
Yep. Somebody was going. So Priscilla, was that you? Go ahead.
Oh no, I was just mentioning there's a question in the chat.
Okay. So the question is, Naveen, that in case the Apex Code rules in favor of ID companies on the taxability of software, can the government possibly recover EL retrospectively?
Yeah, I think that's the point that companies are concerned about, that there should be a sort of a Chinese wall and they should decide a cutoff. This is a cutoff date. The government should come out with its clear intention that whether it should be taxed as royalty or it should be taxed as equalization levy. It should not be both. And it should not be based on what decision is taken at a later point in time. But as it stands today, it seems that they will recover the equalization levy as of now, and the question will really be that if the matter gets decided in favor of the taxpayer, then clearly that equalization levy seems to be there. Otherwise, if it goes against, then maybe a credit. But we will have to see again, as to whether they are able to make this mutually exclusive to the point that whatever their position is on the withholding tax, if that position is that it is taxable, then equalization levy should not apply. But that remains to be seen whether they'll do that or not. But as of now, it seems that both are applicable.
Okay. Any other questions?
This is Priscilla. Just a general question. Like, has there been any kind of understanding from the Ministry of Finance on, because of all of these complexities, a willingness to, possibly listen to the request for delay, whether in the implementation or the payments? Just wanted to get kind of your sense from having interacted at a technical level.
Yeah, so they have been a little bit hesitant to give a commitment on the delay. They've said that this is 3 months time that has been given for the first installment to kick in. So that itself means that we've given you that much time. But it's something that representations are being made that the compliance should be deferred for a couple of quarters, more so in the wake of COVID, that companies are not going to be operational. They would not have the wherewithal to tune their internal systems to gather this report, pull all these reports together and determine how much equalization levy has to be paid. So, I think those are considerations that are being looked at. They are non-committal at this point, but depending on how this plays out in the next few weeks, the situation evolves. They may be willing to. One could hope that they may extend this and make the compliance applicable at a later point of time.
Okay. There's one more question from Ashish from eBay. So a company, if cooperates in e-commerce marketplace and Indian buyers place an order on this marketplace and the foreign seller fulfills this order, basically an import transaction, would the equalization levy be there on this one as well?
Rohit, you want to take that?
Yeah, I think there would be an equalization levy here. This goes back to the first case study that Naveen had called out. So, this would trigger an equalization levy. The question is, on the gross or net, because the margin being made by the e-commerce operator is wafer thin. So, if all of that is taken away through an equalization levy, what remains with the operator?
Ashish, hope that answers your question. If not, then we can definitely reach out to us. We will put you in touch with the experts here. There's one more question. What exactly determines permanent establishment? Does a B2B transaction between the India subsidiary of a foreign company and an Indian customer fall under the ambit of this levy? Is the PE determined by where the billing happens?
Rohit, you want to take that? Or?
So a PE would be determined based on your the tax treaty. So if you look at any of the tax treaties that India has, let's say India and US, so there are different situations under which a tax treaty could be triggered. By and large, the existing tax treaties look at a brick and mortar kind of a situation where some sort of a physical presence of the foreign entity is required to trigger a permanent establishment, and that's the precise reason why the government is trying to bring in this whole equalization levy, where there is no brick and mortar presence, but there is a digital presence, and because you are not getting taxed as a permanent establishment, they want to bring in this equalization levy. Now, to answer your question, if there is a transaction between the Indian subsidiary and the customer, assuming that the subsidiary is transacting independently, there should not be any trigger for a P for the foreign shareholder.
Okay. So basically, it's a principal-to-principal transaction. If it's a principal-to-principal transaction between the Indian subsidiary and the customer, then that's fine because that is being subject to tax any which way in India. But if the Indian subsidiary is acting as a conduit, or if it's acting as an agent, then that creates an issue for the e-commerce operator, create a permanent establishment.
Okay. We have one more question. Whether the option to obtain lower withholding tax certificate under Section 195-197 be explored for transactions subject to EL.
So it's not clearly provided in the context of equalization levy. You already have an option of obtaining a lower withholding certificate from the government to determine, to get an upfront determination. It's not a final determination, but an upfront determination of whether a transaction is, what the taxability of the transaction should be. But at this point, the government has not thought about, how a certainty can be established around it. Again, representation is being made to provide some avenue because not everything will come out in the law or in the form of guidance. So are there avenues like obtaining a ruling from the government through an authority for advance ruling, or some other mechanism can be provided whereby a certainty can be given to the taxpayer? This is something that has been suggested, but we will have to see if some options are given by the authorities or not.
Okay, thank you. Anyone else? Any other question?
I think one question that came up earlier in one of our conversations was that the consideration is on, that talks about amount received or receivable. But if, let's say, the accrual on the books happens at a later date, then when will the equalization levy happen? And a lot of times you would have received the payment in advance, say on March 31st of 2020, but the accrual for the income may happen in a subsequent year. So will that now be subject to equalization levy? I think the answer seems to be that, it should be based on effectively, one would need to look at plain reading of the law seems to suggest when it's received or receivable, but this is an area where they probably should clarify because it could overlap two different accounting years.
Okay. All right. We have one more minute. If nobody has any questions, I'll just ask one question, Naveen and Rohit, one very layman question. So, from the perspective of this levy, look, so it's a sales tax, right? It's a sales tax, and then domestic companies and foreign companies. At this point in time, let's say there is a domestic company and there is a foreign company, and the foreign company fulfills all the criteria of $250,000 per annum. So they are both equal at equal level, equal standing. So let's say both the companies make a sale of 1,000 rupees, right, to a person in India. What is the tax which the Indian company is paying, and what is the tax which the foreign company is paying? So for the purposes of domestic Indian company, it looks like it will fall under the 18% GST, and the total tax which the Indian company is paying is 18% of that. I don't know, maybe you can correct me, but what is the total tax which the foreign company was paying earlier and is now subjected to after this year?
Do you want to go?
Yeah. So Abhishek, let's take the scenario of the domestic company first.
Right.
On the sale of 1,000, whatever margin the domestic company makes, they will have to pay an income tax.
Mm-hmm.
And there is an indirect tax, that's the GST of 18% that is passed on to the customer, but it's still a tax cost in the system overall purchase sale transaction.
Right.
Now, for the non-resident company, if the sale is of 1,000 rupees, you don't pay any taxes, assuming you don't qualify as a royalty or a fees for technical transaction otherwise, but the equalization levy wouldn't trigger. And if it's a B2B transaction, then there is a GST implication in the hands of the customer, where the customer generally pays an 18% GST on a reverse charge. So GST remains the same. It's only the income tax incidence which the Indian company will have to pay as compared to a nil cost in the hands of the foreign e-commerce operator.
Okay, and the income tax out of those 1,000 rupees, income tax can fall. the bracket depends on the sale of the sale amount, right?
Yes. So what margin you make? Let's say if the cost of the goods sold is 990 and you're making only a margin of 995, let's say, and you're making a margin only of 5, and
Right.
on that you pay a 25% tax, let's say.
So what is the minimum tax amount there? So is it more than 2% or less than 2%?
So the corporate tax rate in India is, the base rate is 22% of the profits.
So I think you can't compare the two. I think Abhishek, the point is a company that is registered in India and taxable in India will definitely land up paying higher taxes because it's got a source, it's got a base in India, and therefore it will be subject to corporate income tax. A foreign company which is not having a taxable presence or a permanent establishment would otherwise not be subject to tax unless it gets covered under the equalization levy scope. The GST implications remain the same.
Okay. Thank you.
Sorry, I know we've run out of time, but just a question that I thought of as you guys were talking about that. For the big kind of domestic Indian companies that may have sales channels that are outside of India and not, connected to their PE, has there been concern reflected from them about some of these technical issues as well?
So, Priscilla, there, in the case of an outbound sale, because what is happening is this trigger is for an equalization levy is by and large where the sales are being made to a person resident in India or to a person who's using an Indian IP address. So in a scenario where an Indian company has an outbound sale, one would expect that this equalization levy wouldn't trigger in such a situation because the sale is not happening to a person resident in India.
Right, but let's say a hotel has a U.S. sales channel that is, and the tax is collected, and I don't know what different corporations have different, tax structures. Presumably, this could impact one of their kind of, sales channels for collecting if it's not connected directly to the main corporation in India. Is that correct?
Yeah, so of course, in example that you gave of a hotel, in India, so of those kind of industries, of course, there is an issue that is coming up because, this leads to a double taxation in the whole transaction because the sales channel entity, if it is an entity registered outside India, needs to pay a 2% equalization levy, whereas the Indian company, in any which case, is going to pay income taxes on the profits that it's going to make. So this raises that whole issue of gross versus net that Naveen raised in the case study number 8, where if you have a property or a source or a service being rendered in India, then there is an issue because there is a possibility of a tax on the same value twice unless the government clarifies that the sales entity will be charged only on the net basis.
Great, thank you.
All right. I know we have crossed our limit, 5 minutes over, and it's pretty late in India as well. Again, thank you very much, Naveen and Rohit. It was very, very helpful and insightful. At least I learned a lot today. Not a tax person, but definitely learned a lot today, and I hope all our members also enjoyed the conversation. As I said earlier, we have made a recommendation to the Government of India. We will brainstorm internally, and for our members, if there's anything you want us to take up with the Government of India, we'll be more than happy to do so. So, and this document also, we have, whoever had registered earlier with us, we had circulated this document as well as a pre-read document to everyone. If you don't have it, please let us know and we will send it again to you. And if you have more questions, we'll be more than happy to put you in touch with Naveen and Rohit. So again, thank you very much, both our speakers, and thank you very much for all our attendees for attending this call. We'll check back again. If you have any questions, let us know. All right.
Thank you, Abhishek, and thank you to all the attendees.
Thank you.
Thank you. Have a good day.
Thank you.